5 seconds. Start. Desertion is an act which implies abandonment against the wish of the person charging it. In this case, the respondent left the matrimonial home and started residing separately. The question raised is, will the conduct amount to desertion on the part of the respondent? The Supreme Court, in the decision reported in Bipin Chandra Jaisingh Bhai Shah versus Prabhavati, AIR 1957 SC 176, held that where the wife is forcibly turned out of her marital home by the husband is guilty of constructive desertion. The test is not who left the matrimonial home first. If one spouse by his words and conduct compels the other spouse to leave the marital home, the former would be guilty of desertion, though it is the latter who is physically separated from the other and has been made to leave the marital home. There is no evidence in this case to find that the wife was forcibly turned out of her matrimonial home by the husband. The available evidence discussed above shows that the respondent wife had put an end to the marital relationship and cohabitation. 14 years have elapsed since the petitioner and respondent have been separated. We find that there is no possibility of the parties resuming normal marital life. There has been an irretrievable breakdown of marriage between the husband and the wife. A workable solution is certainly not possible. The parties cannot, in the background of their disputes at this stage, reconcile themselves and live together, forgetting their past. Because of the irretrievable breakdown of the marriage between the parties has been rendered a dead wood. Learned counsel appearing for the appellant submitted before us that no purpose will be served by keeping such a marriage alive on paper, which would only aggravate the agony of the parties. Irretrievable breakdown of marriage is not a ground by itself for divorce. But while scrutinizing the evidence on record to determine whether the grounds alleged are made out and in determining the relief to be granted, the said circumstance can certainly be borne in mind as held by the Supreme Court in the decision reported in Durga Prasanna Tripathi versus Arundhati Tripathi 2005-7 SCC 353. The Supreme Court in the above decision on finding that 14 years have elapsed since the husband and wife had separated held that there has been irretrievable breakdown of marriage between the parties and that reunion was impossible and that the parties cannot at this stage reconcile themselves and live together forgetting their past. The Supreme Court therefore held that there is no other option except to allow the appeal and set aside the judgment of the High Court and affirm the order of the family court granting decree of divorce.